Welcome, everybody, to tonight's Impact Litigation update. It's great to have you all with us. I have Chuck Cook. We have Lily Axelrod from Siskin Susser. Greg Siskin, who's ever smiling. And Jeff Joseph is thinking hard.
I was actually already looking at the comments.
You're always looking at, you're thinking hard, Jeff, and that's good. Except for those of us who don't think that hard.
Oh my goodness, so many comments already.
Well, you know what happens is I have to set this up a little beforehand so I can get you guys the code. And apparently it says we're about to go, then it hooks right to YouTube and says going live soon. So they can comment on it. I didn't know that until last time. I said, okay, cool. So we'll try to get to all those comments. But we have a lot of stuff popping here. And I wanted to talk first really about the Go litigation, because it was really a top of mind today. Jeff, we had the government file today, didn't we? File on Friday, their motion to dismiss, which we, of course, are planning on. It's part of what we're
Chuck,
doing.
can you throw on the banner so that folks can use
yes,
scroll through
thank
afterwards?
you so much. This is why Lily's got to be here to make sure that I'm doing the stuff in the right order here. Here we go. Go. We're go. We're going with go.
Go with go.
Good to go.
So the government filed their motion to dismiss. Lily, did you want to comment on the motion to dismiss? Somebody commented in our group, was like, "Yeah, I think I've seen this movie before." It was
they are sticking to their argument that visa ban, or that travel bans mean visa issuance ban, which is not at all obvious, and they're sticking to the argument that consular non-reviewability, that you can't appeal an individual officer's decision to deny a visa, means that you can't ever tell the State Department what to do about anything, which is
it's a unique argument.
Passing.
It's been so successful.
They also said something like that in consular non-reviewability. Well, because we interpret the rules for visa issuance, that falls within consular non-reviewability. So basically, we're God. We are completely unreviewable from anything.
But more importantly, they're essentially saying that the individual consular officers are more godlike than Secretary Blinken himself, because Blinken is we sued Blinken, but he is hamstrung by the decisions of his very junior consular officers. And
the guy that just graduated from language school and college last week, he controls Tony Blinken. That's right. That's how our government works. I mean, we're joking. It doesn't work like this. But when you don't have any arguments that you're going to win on, and you know what the judge is going to do, I think you just throw it all out there.
Let's talk about the administrative record and go too.
Oh yes, Jeff. So as part of the filing, the government is required to produce presumably the documents they rely on to make their decisions that they're being challenged. Now, what was interesting about the administrative record, broken into two parts. One was almost 800 pages, and the other was, I think, 150 pages, going back to 2017. I mean, this goes back a long way.
Can you explain for the audience what an administrative record is?
Yeah, this is the official records that this department created, in which they makes the decisions for them. So they're controlled by these documents. Now, what was interesting in the Gomez case, Rafa Arenas was able to get the judge to force them to issue documents, and they were very specific documents last year. Oddly enough, those documents, I didn't see them in the administrative record this year. I've been all the way through it, but I haven't seen those, which is odd because they applied to the DV lottery. What was odd about this administrative record is there's really nothing about DV 2021 not issuing visas. And in fact, what they said was, yeah, look, you have to, this is starting back last year. You should prioritize the issuance of visas. And they briefly mentioned diversity visas. But you would think, since they were getting sued by us in November of 2020, that there might have been some more direction about DV visa issuance. And this is why, personally, I don't think this record's complete. I don't. I mean, I don't think it's complete.
Yeah, and so we do have the opportunity to either supplement the record ourselves. So when we submit our motions for summary judgment, we can supplement the record with any evidence that we would want to submit. But we can also use evidence that we have from other cases, right? I mean, one of the great things about this administrative record is I'm looking at it thinking, this is great exhibit for the majority of our cases. Like,
Jeff, I have to say this. Did you see the K1 stuff?
Yes.
This is unbelievable.
It's beautiful for Kinsley, which is due on Monday. I'm due on Thursday.
Great evidence for Kinsley, which we'll get to when we get to the Kinsley hashtag. We'll tell you all about it. But what's we're now, Aaron's drafting our motion for summary judgment and our reply to the government's motion to dismiss, which is due in about 2 weeks.
It's due on June 7th.
June 7th. So, and then the government will respond, and then we'll respond, we'll reply, and then we'll have the hearing on July 13th, and that's where we are. So that's go. And I saw that record. I saw the government's 70-page motion. I don't recall there being I thought it was a 25-page limit. Where'd the 70 pages come from? We must have agreed to that, but
we did. We agreed to it. And they wanted more than that. And Judge Maida said, I don't know if you remember the order, but Judge Maida said, we've been around this rodeo once before, so I'm not going to give you that many pages. You need to be able to do this in 70 pages.
That's a lot of pages.
Especially since they're making old arguments.
Mm-hmm.
You would think you just say, see prior argument in Gomez that we lost. That would be
right.
Nice to that. So let's go. So let's jump right to Milligan, because we were just talking about Milligan and this K1. Jeff, can you tell us the interesting stuff that we got in Go that impacts Milligan?
Yeah, I mean, it's
and Kinsley.
The evidence in there, it literally talks about. I mean, there's evidence where the government actually says we really should be really careful about how this is used in the future, 212F, because it could be really used for discriminatory intent. You know, it could be used, and there's evidence. There's like actual anecdotes back to the times of apartheid, where they were talking about whether they should use 212F during apartheid, and they said, you know, there's just too many racial implications to doing that. We should really be cautious about how we use 212F. And that's kind of that's the beginning of it, right? So they just kind of go through this whole history lesson of 212F. And I'm like, there's not a lot in here that helps you, government.
No, that's exactly what we're arguing, right? Is that the government doesn't have endless power to just stop issuing visas when they just don't like a group of people. Congress says who gets visas, and the State Department has to process visas.
Yeah, so it is really beautiful for Milligan. It's beautiful for Kinsley. It's beautiful for all of our mandamus cases against consulate. It's really good on many, many different grounds to just show that you don't get to have carte blanche to decide when you are and are not going to process visas.
Now, Jeff, one of the things that I caught in the first kind of grouping, the 700 pages, is that they even said this is getting back to November of 2020. We need to give priority to immediate relatives and K1s. They said it in November of 2020.
There you go.
I mean, this is like, Judge, all we're asking them to do
is what they already noticed.
It's absolutely stunning. I mean, there's really nothing in there that I saw that helps their case in argument in front of the judge. Anyway, that's where we are with Milligan. Jeff, you want to kind of give us an update, or Jeff or Greg, where we are with most of our plaintiffs? I was looking at the list, and more interviews are getting set up.
Yeah, I mean, we don't have very many round two people left, except for Manila, which still has no progress that's been happening there. And then we have a few folks from some of the European consulates are still left, but most of those people have appointments scheduled. There's a lot of London people that have their appointments scheduled next month and in July. But a lot of those are actually round three people that have it. So most of our round two people from London, which was a big group, have been getting their visas over the last couple of weeks on there. So we're in pretty good shape. Things are on Milligan, except for Manila, which is the big issue. We're going to have to push the judge to wrap that up. And when we talk about the Manila case, hopefully the two tie together as far as making progress on both at the same time.
Our response to the government's motion to dismiss is due this Thursday. So that will be the next pleading that gets filed is this Thursday, the 27th. So
and we've got some great new evidence to put into that.
Yeah, exactly.
There's no claim here. How's there a claim here? Well, let's use your own words against you to see the claim here. So that's where we are at Milligan. And we do know we have that round one plaintiff left in Montreal, which I will tell you, if she's listening tonight, Jeff is all over the government lawyer about that, just so that you know. So we're doing our best.
I actually asked the government to report back to me if there's something unusual about this case. Like, is there something that we should know? Because literally it hasn't been processed.
It doesn't make any sense from a consulate that's clearly operating. By the way, I was able to confirm with a couple of different foreign national employees, the people that in a country that work at a U.S. consulate. There's a word for that. There's a name for that. Greg, Jeff, do you guys know the name of the category of person who's from that country who works at the U.S. consulate? There's a name. I want to call them foreign national employees, but it's something else. I talked to two separate people in two separate consulates around the world about immigration issues for themselves who work at the consulate, who both told me, even though the consulate's closed, that every single person at that consulate, U.S. citizen and foreign national employee, has been vaccinated. Two different places around the world, not in places you would imagine that they would have vaccines all done. And they're all done. And then why are they freaking closed? And that is what's frustrating. That's what's frustrating. Let's take a look at Anunciato. Anunciato is also in the motion to dismiss stage. We're waiting on the government's reply brief. We have filed our response to the motion to dismiss. That judge has not set a hearing date, at least that I can remember, for the case yet. So we presumably will have that. Their brief is due, I think, this week, if I'm not mistaken. And then the judge will let us know when we have a hearing. But that's our remaining. The government once again asked us if everybody has been scheduled. They said, well, we gave you the list for you to tell us if they've been scheduled. But as far as we know, we still have about 21 or 22 people that haven't been scheduled. And we're going to talk a little bit about that in the question and answer section, going to the issue of how Department of State is reactioning to being sued so much, because it kind of goes to this issue. And a conversation I had today with the government on a case. On our Cairo cases.
Chuck, do you want to go? Lily raised a good point that we promised the London onboarding people to address London early on.
I have London's coming up.
Okay, good.
We have London's coming up. I figured I'd go with the cases we have pending, and then go to the London onboarding case. So London, Cairo, Cairo K1, EBs, family-based cases. I don't think the government's entered their appearance in that case yet.
The Cairo K1 they have. That's the one that's Walker.
Johnny Walker.
Johnny Walker the second.
Johnny
Herbert Walker.
So, but the government hasn't communicated. They haven't issued anything yet. So
no, and we know on these cases that they've already told us what their position is. They've been instructed from headquarters to do a motion to dismiss on every case. So they're not going to settle them any longer. That doesn't mean you won't be scheduled for interviews. In fact, a lot of the Cairo K1s have been scheduled for interviews. I think about half have. But what it does mean is that it's not going to settle in the first 60 days. They are going to file a motion to dismiss. We're going to have to litigate it. And that's the same for all of the K1 mandamus cases.
All right. Now, we do know that Cairo, a lot of the people that were at the consulate have been interviewed already.
Right.
And I think it's NVC people mostly that are left.
That's right.
Cases who, if they haven't arrived on the slow boat, or the consulate hasn't requested it, or the NVC hasn't sent it. We all know the story back and forth.
That's right. The other thing that I'll say about all this grouping of cases that's coming up is that we're not in a lot of urgency really to try and chase down the government every day on these cases, because delay works to our advantage. If we really have 60 days for the government to submit a motion to dismiss, we want them to take that 60 days to try and resolve cases in the interim. So it's not like we really want to push this along.
Or to not. I mean, if we go to the judge, we filed this, they filed this motion to dismiss on day 60. By the way, Judge, during this time, they adjudicated no cases.
Right.
Yeah, I mean, I think that Manila, there's probably a good candidate for a consulate that is, for one where they're going to not do anything given their history
Exactly.
so far, and we're going to be in a different boat with that consulate.
That's
Yeah,
right.
so far I'm not
Rio here,
seeing-
of course, they've been working. The Creo has been interviewing people, and so I know folks have gotten interviews. I know the mule that they attached the files to from the NBC is working its way down through Central America at this point to get to Rio. Hopefully they make it through the isthmus without getting attacked, the files being lost. But so, I mean, Rio is actually interesting because even though we sued them, they're still trying to get stuff done. And we've looked, we've copied, some of you folks send us copies of their responses to your emails, and they're very nice. They're very kind. They're understanding. They're very different from what we get from other consulates. So clearly they're there. K1 Manila. Now, do we have a lawyer in that case yet, Jeff? I can't remember.
We do not have the lawyer.
We do. And this is, of course, this is the consulate who's clearly not reading the memos that their folks are sending. I think this stuff, this discovery and go, is particularly damning against Manila. I think it's wildly damning against Manila because they're clearly violating their own protocols on who should be interviewed. So we know that'll get in front of the judge. They'll go, really, what is going on here? I don't understand this. That's always my favorite question from a judge to the government counsel. Can you explain why this is happening? And government counsel's like, I don't know. And in fact, I think in one of
COVID.
I know in one of Mr. Morris's
cases for everything.
The judge in Mr. Moore's case has ordered the next meeting that they have status conference to have a State Department official present to explain what is going on to the judge. So that might be something that we ask for. So that's where Manila is.
I'm wrong about Manila. We do have an entry of appearance as of the 20th, and it is our friend Joseph Carilli.
Oh, so we probably need to talk to Joe about that. Maybe I'll mention that to him when I tell him the bad news about his discovery.
That's a good thing, by the way, that Joseph.
Yeah. We've been, there's government. I mean, generally speaking, the folks we've worked with have been terrific. Government counsel is doing what they can. But remember, they're like you. They have a lawyer. So they're the lawyer for a client. These government lawyers don't work for the State Department. They work for the Justice Department, and they represent the U.S. government. So they don't always get to tell their clients what to do. They're usually told by their clients what to do, and that's how they react to this. We've got our K1 in Moscow, and I don't think we have.
No, we don't have government.
We just filed that. We did file an amended complaint to correct some name spellings. I'm sorry, my Russian friends. Sometimes it just doesn't type up right or correct something, but that's the Ponomarenko case. I love your name. That's why we picked you, because it's a great name, Ponomarenko. All right, Lily, K1 London. I put a question mark by it. You want to clear up the question mark?
Take down that question mark. K1 London. We are doing it. So
we're onboarding.
We are onboarding. As of now, we have 23 couples on board. So this is a mandamus case specifically for K1s who are either stuck at the consulate in London or stuck at the NVC, but planning to process in London. So just like our other cases, you have to have your petition approved, or your NOA2, if you call it that, from USCIS. And just like our other mandamus cases, what we're asking the government to do is promptly process all of our plaintiffs' cases. And the reason that we're doing a separate one for London is we had quite a few London K1 couples in the Kinsley lawsuit, 46 of you actually. And the purpose of the Kinsley lawsuit was, of course, that the State Department was saying there's a travel ban in place for the UK and many other countries. We can't possibly issue visas while there's a travel ban. And we were even more successful than we expected to be on that suit. And that on the eve of us filing it, the government said, well, we're just going to make a national interest exception for all K1s, which means that they no longer have the excuse of the travel ban to not process K1s. And right after that happened, a lot of our Kinsley plaintiffs started seeing movement on their cases, K1s in other countries. But our K1s in London really weren't seeing movement. So a number of them said, hey, could we do a mandamus claim, which is separate from Kinsley, which is a legal argument about whether they can refuse to process visas with a travel ban. Now that we've removed that obstacle and they still aren't promptly processing, mandamus is a separate remedy where we're telling the judge, hey, these cases have been unreasonably delayed. The State Department can't sit on them forever. London is open, they're processing cases. They've got consular staff who presumably are vaccinated by now. The UK is no longer shut down. We need to get these cases moving. So I know I have heard from a lot of Kinsley plaintiffs that you were really hoping that we would be able to do this for free for you. I understand a lot of you have already, you've given us, you've paid us for Kinsley, you have, endured financial sacrifice from the wait. I hear you. Because there are 46 of you, we cannot do a whole other case for 46 couples for free. We just can't do that. We offered you a discount on the legal fee if you're already part of Kinsley, but it is a totally separate case that will need at least 100 couples to go forward on, and we can't give half of those couples, we can't do it for free for half of those couples, and we can't, set a much higher minimum plaintiff number that we won't be able to meet. So Kinsley plaintiffs, you don't have to join this suit. Your cases should eventually move forward whenever London gets its act together, right? But if you really want to push the government for prompt action on their case now that they don't have an excuse, we would recommend joining Kinsley. So I sent an email to all of the Kinsley London plaintiffs and to all the folks on our waiting list. And a lot of you have signed up already, but share with your Facebook groups, share with your, if you've got friends in similar situations. We'll do our best to answer questions here tonight, but I've heard from a few of you that you're hoping to have a separate video to go kind of more into depth. I'll try to get that done on Facebook later this week, maybe a little earlier in the day, so that those of you who are now coming up on midnight in London can join us as well.
Thank you, Lily. That was awesome.
What did I miss?
This is something that happened in Anunciato. We filed Anunciato in November, right after the beginning of the fiscal year. And that also didn't include a mandamus. It was just a deck action on the same general principle that the bans were not visa bans. They were just entry bans, and you can't not issue a visa. And we couldn't issue a mandamus there, just like here, because for example, mandamus is you're taking too long. Anunciato were many diversity lottery people. They just started the year. There was no waiting too long. There's no way to win a mandamus case. And so that's why this delay and them not recognizing Kinsley folks who have filed months ago and not processing them, I think strengthens their mandamus case. As part
the other thing to remember is that Kinsley's consolidated with Boasberg. With it's not consolidated, but it's assigned to Judge Boasberg, right? That's good for us on the proclamation. He's already ruled our way on the proclamation, but he also ruled against us on the mandamus. So, it's good we didn't have a mandamus claim in Kinsley, because we would have been looking at sort of a universal no. I mean, I'm not going to make a universal claim of unreasonableness. So, and we knew that going in. We knew that there's no judge that would be willing to say universally all these different classes of people, NIVs, IVs, DVs are all universally delayed. So.
Right. Rio to London to China.
Too many varied circumstances, and we didn't want to lose. We wanted to win the case, and so that's the issue there.
Well, and the other thing, why don't you amend Kinsley? Well, it's the same thing in Anunciato. The judge doesn't, Judge Anunciato said, look, you can just keep amending till you get a case that wins. That's not how this works, counselor.
But here's another. It's like even more in the weeds. You kind of have to trust us, because it's so much more in the weeds than that, right? Because really, to get any sort of immediate relief, which is what all of you want, there's only two ways to do that. Either file an injunction or file an expedited motion for summary judgment, okay? Otherwise, we're just sort of in the waiting game, which is what we're doing, right? We're sort of waiting, seeing what happens with cases. But the only way to get quick action is a TRO, injunction, or motion for summary judgment. A TRO and an injunction requires us to show irreparable harm. Right? In other words, if you don't take this action, there will be irreparable harm across the board. That's really tough to make a claim of irreparable harm universally for all plaintiffs. And we risk losing the injunction, right? We risk losing it, which is not not a position you want to be in. With summary judgment, you don't have to show irreparable harm. You just have to show that you win the case. So there's a lot of reason not to file an injunction and to wait and move straight for summary judgment, which is frankly our plan on Kinsley, because the standard of proof is much lower.
So there we go. We've got that's our K1. Stay tuned for Lily to announce when our London K1 Facebook Live is going. EB5 Fang, the government has to file a response to our TRO. And that's due this week, if not even today. Government called and they wanted more time. And I know of our 23 or 24 EB5 folks, 7 of you have been either interviewed or scheduled for interview today. I think there's one in somebody else in early June. So the government wanted more time to respond to our TRO. But the rules in California where we filed this is that the last plea, the response to the pleading, precedes the hearing by 21 days. And our hearing is set for June 14th. And I told them we're not going to extend the hearing date because EB5 ends, technically, even though I don't think it will, on June 30th. So you have to respond. So they may file a motion to dismiss, which is fine. File a motion to dismiss, you can tell it to the judge. Our Fang case is a very strong mandamus case because some folks have been waiting for 5 years for an interview. This is a green card. It's actually outrageous. They have $1 million on the line. It's completely outrageous. They're not doing it. And they wanted one more week to see who else we could schedule. Well, you've had 2 months. So that's where we are at Fang. We're fighting for you. We feel confident we're going to win that case and get those visas issued by June 30th. All right. One thing I forgot to mention, and I want to go back to Go for a second, is that we have provided the government with a complete list of all the plaintiffs, all the case numbers, and where your cases are. The government has intimated that they needed this so they could get the cases cleared by the NBC. They said it was kind of funny in a way because they're only going to have 3 months to do these cases. Yeah, that's kind of the purpose of the lawsuit. It's kind of why you needed to do it. Guys, I've had a lot of people email me and DM me on Twitter. Are we going to add plaintiffs to Go? And I said, I don't know. I'd give them the waiting list and they can sign up on the waiting list. And I know there's other lawyers filing lawsuits, but we already have a lot of people that we're helping there, and we have made no commitment to file to amend Go. I would not file a separate lawsuit on the same issue. I think that disingenuous as far as, especially when we're in the court with the judge that we want to hear the case on. So it doesn't mean we won't. It just, put your name on the waiting list, and if we get enough folks, we'll amend the case again. Another quick update on Gomez Acker. There's no update. Remember this has been a month now when we had the discussion with Judge Mehta on the hearing date in Go. And, when do you want, we mentioned Gomez, he mentioned Gomez, maybe we should do it together. And we filed a response and said, no, Judge, don't do them together. Make a decision now. Have a hearing now. Nothing. Complete stuff. Because I don't think the judge had time beforehand. I really don't. So that's where we are. We don't have any news on Gomez or Acker. On the 01 lawsuit, I just had a consult today. We are not going forward with the 01 lawsuit. We did not get enough people to sign up for it. So that's canceled.
I don't know if it's already been handled as far as the refunds for those folks, or see what they want to do. But if it hasn't, it will be happening in the next couple of days. Yeah.
So if you want to know one, we're actually about to do one for an individual who was just, I think, getting the royal screw job from London. And so we'll go from there. Now, Greg.
And anyone, just because we're not filing a big lawsuit doesn't mean you can't file an individual lawsuit. So if you have the resources, absolutely, you should file an individual lawsuit.
Absolutely. Now, Greg, the H-1B lottery lawsuit. Are we live yet? Are we have signups yet? Are we close?
As we were going live, I was reviewing everything. The apps look ready. The engagement letter app is not quite ready, but the declaration app is ready. The website's ready. So if it's not done by the end of this call, it will be happening this evening.
Okay. And this H-1B lottery lawsuit is to get 100 plaintiffs to challenge how USCIS ran this year's lottery in an attempt to convince them at the second round of the lottery to not include multiple applications for the same individual from different employers as an abuse of the system and illegal under the law, and certainly not to have it in next year's lottery. There's no guarantee of a result. There's no guarantee an individual will get any particular benefit from it other than if the judge agrees with us, presumably their odds would improve on this year's lottery and what's left, and we don't even know how many's left, and certainly in next year's lottery. So that's kind of where we are with that. Let's see, is there any, there's one other case that I know that I can't remember right now.
I'm so excited about. I'm every day I think
there's a lot of stuff going on. If I forgot something, guys, you have to let me know if I forgot something, but I don't think
Have you mentioned anything about that one yet? Because I'm going to try and get that ready to go this week.
No, we have. You want to mention that, Greg?
Yeah, we have been we've been discussing. We think that there's a good claim regarding a mandamus claim for employment-based adjustment of status applicants who filed based on the rollover of green card numbers that happened in October and November. This is primarily Indian nationals who have been in long waits for green cards. You guys have to get your green cards issued by September 30th, or all those numbers essentially evaporate. And it's they don't go back, even though they were taken from the family numbers and technically roll back to the family numbers. This weird way that the green card system works, there will be none of those numbers will actually be used to increase family-based green card numbers. They all get wasted. And what that means is that the line, I mean, there's 100,000 or so green cards that are not going to be in the India line if we are not successful with this. Some people might wonder, well, if new numbers are going to roll over, which is going to happen on there, then why should I be a plaintiff in this suit if I'm going to get those numbers that are going to benefit us down the road? And essentially, and Chuck and Jeff, I think you guys always do a better job explaining this, is that plaintiffs in these cases are prioritized if we're successful. So rather than one way to think about it is essentially, one is that you're helping the whole community because all these numbers are going to be made available, but it's sort of like printing and processing, or at least a way for you to get toward the front for processing if we're successful in this, because you'll have already been unreasonably delayed if your case is pending a year.
Chuck, can you throw up a new banner so that folks
can
find
yes,
this?
I'm so sorry. Thank you.
But anyway, we are going to start onboarding for that very soon, hopefully this week. But that's like the number one most requested thing that we get on social media as far as an area to litigate, is to make sure that that we deal with this issue for folks that want to get their green cards finished that are from India that have adjustment applications pending.
And please be polite on social media. I've had some people be
I know, it was
to me
so
on
crazy.
Twitter.
Somebody was like, we said we're working on getting this thing onboarded, and somebody was like, basically called Lily a liar, that we weren't going to, there was no chance we were going to file this case. And it's like, you.
Or that we were going to wait till after October to collect your fees, knowing that we couldn't wait. Like, why?
Oh, really? You just got to blow people like that off.
I know.
Anyway,
the other thing that's interesting is
it will be a nice thing if we're successful on that. I think that there's no downside on that to winning. Nobody loses green cards. It's not moving, and it's genuinely a win for all immigrants if we can keep these green cards in the from being taken out of the system.
One of the important parts of that, I think I want to address again what you kind of explained, is why these visas disappear. Because again, they're supposed to go back and forth, right? So everybody understands back and forth. And there's a special rule on family-based visas, and the cap for family-based visas is, I think it's 435,000. Okay, but they subtract from the 435,000 every immediate relative case. So any immediate relative visa that's green card that's issued is subtracted from the 435. Well, every year for a very long time, there's about 500,000 immediate relatives that immigrate every year. So there's another special rule that says, so you reduce that 435 by the number of immediate relatives to a minimum of 225,000. So everybody in family base is splitting 225,000. And so let's say you tossed another 100,000, 150,000 from employment base back, they're just going to get eaten up by the immediate relatives. That's why they disappear, because the number of immediate relatives is so big that it will eat basically anything that's sent over from the employment base categories. It was a brilliant piece, as Greg made this point, a brilliant piece of writing by the anti-immigration movement back when this rule changed in 2004, 2005. And so it's that's why we have to fight this. Because the other thing is, as far as we can tell, guys and ladies, we haven't had a single client who filed in October get approved yet. Their adjustment, not a single one. In fact,
we barely have receipts.
They don't have receipts. They don't even have their EADs yet.
No,
they don't have biometrics. I mean,
this is outrageous. And so I don't know. Charlie Oppenheim said in an event a couple weeks ago, he's really proud of USCIS for using numbers this year. What numbers are they using? Because they don't appear to be approving any of the Indian nationals who filed in October. And why that's important, and you go back to something that Greg and I had a fun time with last year about, which is there's about 700,000 to 800,000 Indian nationals in the lines. This year, there's probably 200,000 visas for them to use. Next year, there will be 200,000 plus visas for them to use. If they don't use them, the line just keeps being long. So it's inherently unfair that USCIS is not maximizing the use of these visas. So one of the things we'll ask for, even though it's not sound crazy, but we did it in the DV litigation, is to preserve those visas. So they don't roll over to family where they'll be wasted. Now, we don't know if they'll be successful in that, but that is worth the effort because it helps the entire community. And if we can reduce the waiting time from 75 years to 10 years to 5 years, I mean, that's miraculous because nothing's had to change other than USCIS doing their damn job.
Yeah, I love this case because we're not asking that anyone change the law. We're just asking that you allocate the numbers in a way that is fair and actually counts them. And I don't think any judge would be like, why are you not using available numbers?
There's one other thing I think it's worth mentioning, and it's sort of like and Chuck, Jeff, and I have been practicing long enough that we remember the old way before these rules changed. But we used to have this problem every year where there was no rolling back and forth. It was basically there were the family numbers, the employment numbers, and if they didn't get used in that year, that the numbers were wasted. They just evaporated. And Congress didn't like these numbers getting wasted. They wanted to maximize the use of the numbers. So they said, well, if the numbers don't get used in family, it probably means there's not enough demand for family numbers. So we'll let those numbers roll over to the employment side where there's hopefully more demand on that side and vice versa. It was never intended. It was intended to reduce the waste on here, not to contribute to waste. Now, what's happened with a nefarious administration, Trump administration, that really wanted to reduce immigration overall, is they figured out a way to game the system to waste numbers, deliberately waste a lot more numbers than it ever has been done in the past by basically all they need to do was delay for 2 years. They use the 1 year for COVID, and then the next year, if they don't adjudicate those numbers within 12 months, all the numbers get wasted. And that's all they have to do to basically get around Congress and waste all those numbers. And that's what we're going to tell the judge.
You know, I think it's a great lawsuit. I think folks should participate in this. We'll have a reasonable fee for family, because most people are families that are involved in this. We'll have a reasonable fee for this. But this is something that I think has to be done. Because, you know, think about this. Most family-based immigration, that's done by consulates. And so there's never really been, up until the last 2 years, any really fall off, any drop down from family to employment. because family almost always got fully used because consulates were churning and they were getting the numbers done. And once they had once the Trump administration saw the opening here and said, oh, we can just stop family-based immigration. And then we could stop employment-based immigration in the United States. So this is something that I think is really primed to bring home a good result for folks and have a long-term, super consequential impact on this process.
So let's be super clear about who can join. Who is eligible? We haven't put out the FAQ.
No, we will. That's a great question, Lily. I think what we're focused on is individuals who have pending adjustment of status applications filed in October or earlier of 2020. Now, there's a lot of people that filed
in November as well.
In November.
Yeah, well, keep in mind, there are people that filed 5 years ago that don't have their adjustments done yet because their numbers retrogressed and then unretrogressed in October. So there's a lot of people that could be using these numbers. I mean, it's still unclear. I mean, we'll have to dig through the USCIS stats. And I don't recall if they tell you how many cases they have pending, but I don't think they tell you by country how many they have pending. We'll have to go back and dig through those stats from the USCIS statistical page. But that's something, of course, we'll get in discovery with this. But it's something we want to move on, and we want to move on quickly in June because we certainly need to file before the end of the fiscal year. So that's kind of.
And does that include folks who filed only based on the final action date, or also folks who filed based on the filing?
Well,
chart?
I have a thought on that. I mean, that is that when they set the filing date chart at the beginning of the year, that's based on what they believe that they have the numbers to adjudicate by the end of the fiscal year. They don't set that just to be nice so that a lot of people have an opportunity to file an adjustment application. That's their forecast for where they should be by the end of the year. So USCIS needs to be working on all these cases all year long on the assumption that they are going to have the numbers available to approve all those cases by the end of the year. If they don't, that's Charlie Oppenheim's mistake. But that's his base, when he sets those numbers in the visa bulletin, that's his forecast for how many they're going to have available to them. And if USCIS is not working on those cases, then that's something that should go in front of a judge.
And that, of course, is something that Charlie works on with the USCIS. He doesn't do this in a vacuum as part of this process. He absolutely does it with the government with their help on this. So,
and for those of you who don't know who Charlie Oppenheim is, he's like the Department of State Wizard of Oz. He really is. He sits behind a curtain and he looks at the numbers and he's like, yes, you get this many and you get this many and he really does it. And he's brilliant at it. He uses a formula for doing it, but it's his only job is to manage the visa bulletin.
By the way, I think tomorrow, if not today, is Chat with Charlie.
It was today.
Is it today? I didn't listen to.
I haven't listened to it yet. I will be.
We don't know what Charlie has said today. We don't, but you can go watch the YouTube channel, which is the YouTube U.S. Department of State Consular Affairs channel, and watch the Chat with Charlie, which, by the way, originated with the American Immigration Lawyers Association in a liaison meeting. The Chat with Charlie. They decided to take it big time. I love Charlie Oppenheim. I think he's a extraordinarily honest and diligent government employee doing his best with what he's got. I mean, I love Charlie.
The only nugget that I got from an AILA attorney who was listening in was that there will not be a big jump in October like there is every other year because numbers are moving so aggressive. Numbers will continue to move very aggressively all summer. That's the nugget that I heard.
What numbers
does that mean? Does that mean they're planning to adjudicate these cases?
He again stressed apparently that USCIS is moving on cases. All I can think about is maybe that there's a movement to waive interviews and that they're just going to start pumping out approvals. That's all I can think of.
Do is change a policy, right, Jeff? It's made up to interview people. Bam. Right. I just don't get it because they're certainly not scheduling employment-based interviews in my office for the last month. Mm-hmm. Nothing coming up in the next month. So hopefully they're waiving them and then magically they'll approve all of them. But
if they want to avoid getting sued, they can announce what their plan is because that hasn't happened.
They can tell the judge. Sometimes filing a lawsuit is simply meant to move them. Exactly what happened in Kinsley. You sue them, they have to respond. They change the policies, they don't have to respond. So there we go. Couple questions here. We have already the government fight. This is a question I wanted to get to. Jeff, government fighting mandamus cases.
Yeah, so it just means that, normally, like, I think if you've listened to these before, when we started doing these, we would tell you that the government doesn't like to fight delay cases because they're hard to win. And that's true. It's still true. But there's now, we know of 68 different cases pending around the country against Department of State that are mandamus cases. And Department of State is overwhelmed trying to defend the cases. And so what they've done is they've drafted a template motion that they've sent out to all the U.S. Attorney's Office around the country for all 68 cases. So they've done the work for the U.S. attorneys. So there's less incentive for those U.S. attorneys to fight the cases. And their clients, Department of State, is instructing them to fight them, to file a motion to dismiss. So that's what we're going to get on all of these individual mandamus cases against Rio and Brazil, Rio and Manila, and the others. We are going to see a motion to dismiss. It's not going to be a surprise. It's going to be the exact same motion that we just got in the other cases, in the Go case and other cases. That's what
Anunciato, same one.
So, we already know what they're going to say. We just have to go through the mechanisms of responding to it. And then, moving for summary judgment shortly after that. Once all the evidence is in and the administrative record is in and the motion to dismiss is in, then moving for summary judgment after that.
So,
For folks who might not remember previous explanations, I've gotten some feedback that folks are like, summary judgment and discover, like, what is all this? What does it mean to move for summary judgment?
So when you file the complaint, really the government can either approve the case and settle it, or they can try and get the case dismissed, right? And so the way that they get the case dismissed is to argue that we don't have jurisdiction, or that the claims that we're making don't really make a case.
We didn't sue the consular officer.
We didn't sue the consular officer.
Yeah, that's one of the arguments, the nutty arguments that they're making is we don't have jurisdiction because we sued the consular officer rather than the department, or we sued the Department of State rather than the individual consular officer. You can see that these arguments have to be based on jurisdiction or failure to state a claim. We've already won this issue so many times that they're really reaching at straws. I mean, they're grasping at straws on these cases. So I'm not too worried about the motion to dismiss, right? Part of that motion to dismiss is that they have to produce an administrative record. They're telling the judge, based on this record, we think that the case should be dismissed. So once we have that record, we can then move for what's called summary judgment. In other words, based on all the evidence in the case, judge, we think that you summarily should decide for us. And normally those are cross motions. We work with the government and they submit a motion, and then we submit a response, and then we submit a motion and they submit a response. So it's sort of like cross motions for summary judgment. And then the judge decides who wins based on those summary judgment motions. And so
that's when there isn't a trial. We're not really arguing about the facts.
No.
We're arguing, do we win as a matter of law? Everyone agrees that these cases are delayed and not moving forward. And is that enough for the judge to just order them?
Yeah, in fact,
summary
judgment's not appropriate if we don't agree on the facts, right? If there's a dispute of the facts, then the judge has to resolve that before summary judgment. So when we're moving towards summary judgments, it's based on kind of an agreed set of facts. Like, we agree that this is the facts, who wins, right?
So that's why we're not, if you watch a lot of courtroom TV and you see these dramatic trials where we bring in witnesses, that may happen in any of these cases, but probably we're arguing about the law and actually agreeing about the facts. So we don't need a trial. We just need to argue on paper.
Right.
All right, next question is from Sona. Let's say the government, we win or they make a mission critical. Keep in mind, if you're a plaintiff, we know they're looking for your case. I mean, because we gave them a list. So yes, and at this point, every number is current. So as far as we're concerned, order is gone at this point. And we learned that in Gomez. It's kind of a first come, first serve. And the plaintiffs were at the front of that line, and they will be this time with the government in the case. All right.
Yeah, I think that may deserve some explanation, right? So normally this is like two races, right? It's a race because you're assigned a number and you have to wait for that number to happen. But then it's a second race once your number is current to filing for adjustment or going to the consulate and getting your visa. In this case, there's only one race because there's nobody getting DV numbers. So they're all current. Everybody is current, right? So there's only really one race, and that race is who gets the green card first. And so if you're in the country adjusting, you're at an advantage. If you're outside the country, you're at a significant disadvantage.
Charlotte, we look forward to getting you in the K1 lawsuit. She has been instrumental in organizing it, and we love Charlotte, and we want her
Thank
over
you,
here to get
Charlotte.
married.
Yeah, thank you, Charlotte, for all the work you've been doing to try and rally plaintiffs.
Okay. Jack asked if we can show you the administrative record. We will have the administrative record out to you, but not yet. We want to. We have things in it that we need that we do not want out in the sphere. But yes, we will get you. The administrative will be made public. Okay. Just can't do that quite yet.
And frankly, we want it to be made public.
Yeah.
There's some good stuff in it.
There's some great stuff in it, and we think it'll be very helpful for people to get.
It'll be made public, just not today.
Yeah, just not quite yet. All right. Let's see. We don't have that lot of time left, so I want to go through the ones we do this here. This is a good question because people do ask about this. The government to cover attorney's fees in the K1 lawsuit. We always ask in every complaint for attorney's fees to be awarded. But to win attorney's fees, you have to show to the court satisfaction that the government's position is substantially unjustified. That's a reach in these cases. I mean, we think they are, but that's a big reach. That's a big reach. So we asked for it, but you need to go into this. First of all, look at the agreement as part of the lawsuit, because that's not part of what you get back. All right. But it's highly unlikely that will happen. Highly unlikely. And
yeah, I mean, attorney's fees
too.
The purpose of attorney's fees is really to encourage attorneys to take on civil rights litigation pro bono, with the idea that they can still get paid if they take on those kind of cases. But to do attorney's fees in a case like this, we'd have to prove that each one of you is below the threshold for even qualifying for attorney's fees. I mean, the amount of work that would go into litigating attorney's fees would be enormous for a real small chance of recovery. So unless we settle for attorney's fees, we probably won't go after them.
Gorky says, hey, people with higher numbers than mine are being processed in South America. That may be true, because at this point, everybody's current. And again, as we said, we've given the list to the government to get on the KCC to get these cases ready to process. Okay. Let's see. Sammy, I will tell you this about the things we got from the government today. There is no singular cable that we have found yet that's only on DV 2021. None. DV 2021 is discussed in other cables, but there is no singular cable that it's 800 pages. I haven't read every page, but looking at the index, there doesn't appear to be a singular DV 2020 cable, which in and of itself is kind of crazy when you think about it, because this is not that important that they don't need to discuss it. So there you go. Let's see.
That's a cool picture, by the way, Sammy. Looks like artwork.
Yeah, he does. He looks like a Rembrandt, doesn't he?
Yeah, it's really well.
Like a Rembrandt, except he's got the earpiece in. Looks like an iPhone earpiece. Look at that. I can't really tell, but let's see here. Let's see. Some people have asked about some other lawyer filing a big case. Again, we don't track other lawyers' lawsuits. We are busy enough with our lawsuits. We don't run our firms around other people's lawsuits. So all I can tell you is you make the best decision you can for you and your family. That's what you should do. All right. Let's see. This is an interesting question. I've actually had this happen several times recently. Folks that can transfer their visas because they themselves have another citizenship. So they're like Venezuela signed to Bogota, but they're also Salvadoran. And as we've told you, you need to, if your case is at the NVC, you contact the NVC to transfer it. If your case is at the consulate, you contact the consulate to transfer it. But transferring it doesn't mean it's going to happen. And where's the file? I know some people today were told in Warsaw that Moscow lost their file in transit.
And they had to upload all of their documents to see. I mean, all of it. So, yeah.
So Moscow, I'm going to tell you. Maybe you guys disagree with me. I don't think that's unusual, but I am shocked because shouldn't the whole thing be electronic?
Well, I don't know. KCC's that does do it through PIMS, right? I mean, it should be in PIMS.
Yeah, and NBC's PIMS, it should all be there. This is
They
what's
said that they see that it's there, but they can't. Someone forwarded to me like that they see that it's there, but they can't download it. Like, I don't know what's going on with your computers, but they're making applicants
they have this really
re-upload.
cool program called PDF from Adobe that lets you look at documents. And Dropbox, you know, Dropbox. By the way, I thought this was fascinating. The government didn't just email us these documents today. They sent them in their portal, which took me like 5 minutes to get into, getting different keys from different places. I thought, man, this thing is secure. So I'm glad to know. And if that's secure for us, how are they losing documents? If we can get into it. Okay. You know, probably what it is, every agency has their own process. So what we saw from the DOJ is probably super secure, and maybe others aren't quite the way. Okay. Let's see here. If you guys see a question that you would like to answer on here, let me know. I'll just kind of go on this. I'll just tell you, in Go, I think we have about 900 plaintiffs or so, not including family members. So I think there's like 900 or so. Let's see. Okay. And let's see here. This is a good one. Somebody said, "Look, you know, we're running out of time on TV." We know. This is why we're also asking for the judge, like he did last year, to reserve visas for our plaintiffs. Now, if he wants to reserve them for everybody, we'll ask. But if they don't think they can get all our cases adjudicated by September 30th, he's going to have a hearing on September 30th to reserve the rest of the visas for our clients so they can get done. And it's the last one on here. KCC average reply time is 25 days. You know, when we were doing Gomez, they were responding the same day, and that's less than a year ago. So what I love about their arguments sometimes is, Judge, we're overwhelmed with work. All these cases. Well, the next follow-up question is, why do you have so much work? Well, we haven't worked for the last year. And whose problem is that? So they have literally created the problem that they now want to use as an excuse to not solve your problem. I can't wait to have that oral argument. I think that's just great.
And you can call KCC, or no, you can call NBC. Can you call KCC?
I think you can call the KCC. You know how we can find out? If you Google KCC phone number.
NBC answers their phones. I don't do enough KCC cases.
Up until this year, I'd never done a DV case.
Really?
No.
Wow.
No, so many folks do them on their own.
I'd adjusted them once they got their number, but it was like no reason to really. I mean, I would just point them to the DV portal and have them do it themselves.
Yes, 606-526-7500 from 7:30 a.m. to 4 p.m. 606.
Marina says they never answer. Connor says they never answer. Oh.
So, don't call after 4 o'clock Eastern time.
But that's, whoever the U.S. citizen is in the couple, that's a good call to a congressional person, right? I mean, if you're not able to get through to a government agency, that is something that a congressional representative will help you with.
Yeah. They don't answer, won't respond. By the way, if you're a Go plaintiff and that has happened to you, you've called 50 times, I would love a declaration from you. Just write it up. Look, my name is such and such. This is my case number. On the following days and times, I called the KCC. They have never answered me. Under penalty of perjury, I signed this. I would love a declaration. They
don't need to, right? Even if they've submitted a declaration previously, they can submit a new one.
Yeah. So, I mean, I think that's great. I can't get a hold of anybody from a place that works remotely. It just seems kind of crazy to me. All right, guys, our time is up. It's been a great week. We appreciate all of our clients, all our friends who listen. I don't know why that keeps coming up here. I can't seem to get that off of here, but we are going to do that. So there we go. until next week, you guys have a great week.
Hey, wait, next week is Memorial Day. So
Oh,
we're
Oh,
skip
yeah.
next week.
Yeah. Should we do it on Tuesday night?
If you want to do it on Tuesday night, that's fine. I mean, I have my thing on Tuesdays, but I might skip, or I have to look at our scheduling for next week. If we want to do this on Tuesday night, that's fine.
I mean, I can do it Wednesday night too. Those are fine.
Tuesday is okay.
I can do either Tuesday or Wednesday.
All right, we'll send a notice out on Mondays, and we'll be on Tuesday with the data. All right.
Our inboxes will blow up if we wait till Wednesday.
I know. But it's in the United States, it's a federal holiday. We are mandated not to work and to go to the beach and drink lots of cool stuff. That's what
I'll be biking all day.
Yeah. All right, guys. Have a great